Welcome to another episode of Law and Research Network webinar series. In today's episode, we will discuss the matter of global importance, the equitable distribution of water resources under international laws. In this webinar today, we will discuss the intricate web of international laws, agreements, and principles. We will also discuss the concept of water ownership under national laws and international laws. And we will also discuss whether this frame can be revised under international law and what are the challenges. And finally, we will discuss if, under the principle of cooperation, can the complex water conflicts in the South Asian regions be resolved. Today we have our esteemed guest speaker, Dr. Philippe Cullet. Dr. Philippe is a professor of international and environmental law. Dr. Philippe has qualification in law and development studies from Geneva University, London, King's College and SOAS, and Stanford University. Dr. Philippe is also a visiting professor at the National University of Delhi. Dr. Philippe co-convenes the two postgraduate degrees in environmental law in the School of Law, the LLM and the MA in environmental law and sustainable development. He is also the convener of Law, Environment and Development Center and is the editor of the Law, Environment and Development Journal, Lead Journal, a peer-reviewed academic journal published at leadjournal.org. In 2019, he became a member of the group of experts of the government of Madhya Pradesh to prepare the Madhya Pradesh Water Strategy, including drafting the Madhya Pradesh Right to Water Conservation and Sustainable Use Act 2019. He is currently working on river rights and nature rights and is the chair of the IUCN World Commission on Environmental Law, Task Force on Rights of Nature. Dr. Philippe's main areas of interest include environmental law, natural resources, human rights, and the socio-economic aspects of the intellectual property. He works on these at the international level and in India. His current research includes work on water law and governance with a particular focus on groundwater, drinking water sanitation, intersectoral water allocation and institutional reforms in India, equity and justice in environmental law, biodiversity, including benefit sharing and biosafety, climate change and justice with a particular focus on environmental and water rights. Welcome to our webinar series, Dr. Philippe.
Thank you very much for inviting me and for
you're
very long introduction.
Yes, but you've done quite impressive work and on really pressing issues that are of global importance in today's world. So we look forward to having an interesting discussion with you today. So Dr. Philippe, my question for you is that what is the framework for equitable distribution of water laws under the international water laws?
Well, okay, at the starting point in terms of transboundary sharing of waters, but it's actually focused on transboundary or shared rivers that are shared by more than one country is what we know as transboundary watercourses. Over time, progressively, it's taken decades, if not more than that. It started with upstream countries trying to say that they can control the whole flow of the water, therefore why should they share? Some of the downstream countries said, but we're at the bottom of the scale and therefore we need access to all the water that comes our way. Therefore, you as an upstream country can't take it all. And eventually, progressively, these extreme or at least the absolute positions were changed progressively, were changed towards what we today know as equitable and reasonable use, which is essentially the idea that each country can assert its right to use the river as it is in the part which is under its own sovereignty. But it can't insist on saying, I want everything. It can't insist on saying the other can't do everything. In the middle of that, what is equitable and what is reasonable remains to be discussed, namely negotiated between each set of countries. And okay, the reason why we have this principle at present is because that's the middle way, essentially the ways that can satisfy both the upstream and the downstream countries. At the same time, it's a recognition that the upstream country always has a little bit more power over the watercourse, because at the end of the day, physically, they have more control. And therefore, the principle, in the way in which it has been enshrined in the relevant convention, the UN Convention of 1997, is slightly more favorable to the upstream country. But on the whole, it's about telling countries that there is a need to share, and then within that, you can frame it according to the needs of the specific river basin. So this is to say that there's both a framework at some level, but also that it's very broad and in principle very flexible. That still does not seem to have satisfied many countries around the world, which have refused to sign up to that treaty which enshrines this basic principle of sharing. So that's why also all that needs to be contextualized, because it's an easy principle at some level, but clearly it's not yet satisfactory for the majority of countries around the world. Now, I'm saying it's not satisfactory, but at the same time, when it comes to the crux and you need to find a set of principles to negotiate on, when there is, let's say a river basin, as has happened, for instance, with the Nile, where the upstream and the downstream countries don't agree at all on what should be the sharing principles, then the only set of principles that can rally more or less all countries is the set of principles which starts with equitable and reasonable use. So it is there, it is enshrined in treaties. The treaty is not widely ratified, but at the end of the day, that's the only thing on which states can agree on as a starting point for sharing watercourses.
Dr. Philippe, you have defined that it's a middle ground for the states. Obviously, they cannot have complete sovereignty. And then again, where there are water conflicts, so it has obviously served as a guiding principle to solve the complex disputes between the states. So if we try to understand the concept of water ownership under international law, how does it differ from national laws?
Okay, that's where we have very complicated matters at hand, in the sense that at the national level, there's been a lot more development of the regulation of water, which is defined in terms of all sorts of different water rights, rights for individuals, rights for the state, non-rights, the idea of non-rights or water as a commons, because that's been the long-standing understanding that water is so basic to life on Earth and human lives that it should not be owned by anyone. So at the national level, there is that whole mix of different things that come through in different ways in different countries. But there is often at the bottom of the pile the idea that nobody should be able to own water because of its crucial importance. Then there is a layer of the state trying to assert control, again, because water is so important, and it may be from a sense of power or from a sense of welfare in terms of water. Everybody has to access sufficient water if a particular governance regime or government is to survive. And then there are also all the individuals, it's both individuals, landowners, private sector actors, who also seek to have as much control as they can over water. So in that typical framing, there is normally no ownership of water. That's often the starting point in many countries. But because of these different pressures coming from different sides, there will be different types of rights which arise. Often they are simply rights of use rather than rights to own water. So since you started the question with ownership, there is often no ownership of water. In practice, maybe it doesn't make that much of a difference, because if you have the right to use, that's what you actually seek to do at the end of the day. But that also leads to certain fictions, like typically in those privatized systems of water services, so in the places where pipe water services have been introduced, typically in urban areas in most parts of the world. and then that is privatized. Often the private utility will be only charging its customers, in the water users are then called customers, a fee for sending the water through the pipe, cleaning it, whatever it is that they may be doing, but the users don't pay for the water itself. That in recognition of that non-ownership. At the international level, it's a bit different because the starting point is states asserting sovereignty, and specifically permanent sovereignty over natural resources. Water is not a natural resource like other natural resources, but very often it is still part of the lot when states think about natural resources generally. So states have had the tendency to also assert strong rights. Okay, usually we don't call it ownership, but at some level it's akin to ownership. And with water courses, so that's what we were just discussing before, there is that understanding that you cannot assert absolute sovereignty because otherwise that leads to these very unrealistic outcomes, typically the upstream country saying, I can completely dam the river, divert the whole flow, and there will be nothing left for the downstream countries. But that tendency to assert ownership is very strong, and the way in which we can see it appearing and reappearing is that the latest, which is not that new, but the latest state policy statement we have on the matter, which is a set of draft rules concerning shared groundwater, shared aquifers of the late 2000s, still actually goes back to saying states have full sovereignty over the share of the aquifer found under that territory. So that will, in a way, to try and assert as much control as one can, is very much there, both at the level of individuals at the national level and states at the international level.
Dr. Philip, states at international level assert this sovereignty. So as you discussed that water is a universal life force giving energy, and obviously it sustains life. So under international law, do you think that these changes can be devised, and what are the challenges if changes to the framework under international water laws are introduced?
Okay, at the international level, that's a big challenge because, in a sense, water law is very underdeveloped. At present, we essentially have that convention on shared water courses, which itself is not particularly progressive, both maybe in terms of not giving water a full understanding of water as a commons, but also not very progressive in terms of not having a recognition of the human right to water. The convention was adopted a bit before the debate on the right to water really became visible at the international level, but there were already countries that recognized the right to water by the time the convention was signed, so it was not an unknown debate. Similarly, and maybe more striking, the convention is relatively weak on its environmental framing, and that's despite the fact that by 1997 there had been a lot of talk on environmental protection by then. So clearly the law is relatively underdeveloped and has not necessarily caught up with other fields of international law. One of the reasons, I'm sure there are lots of reasons, but one of the reasons is that historically the focus for water regulation has been more on the use that we can make, that policymakers in the first place envisage we can make of water, rather than on its protection or rather than on the social dimensions, which then could translate into the human rights debates. So all of that can definitely be done. Over the past 20 years, typically there's been a fast emerging policy debate, not just academic or civil society debate, but also policymaking debate arising around the recognition of the right to water at the international level. So that's something which is clearly changing and relatively fast, but that has been done in the context of human rights law. In terms of environmental law as well, there's been a lot of developments in the sense that water is virtually always understood as being part of whatever element of the environment one is talking about, which makes sense because very often you cannot dissociate those two things. But what remains to be done is bringing, let's say, just to give these two examples, the human rights and the environmental debates that are happening into the water framework. And the problem we have that's not specific to water is that all these areas of international law develop in specific silos. Each silo tends to not understand, okay, obviously it's not the law itself, but the people working in the system not understand or not look over very much to what's happening in other fields. And therefore it's been and it remains a challenge to link such different fields, even when they are closely connected, as would be the case here.
Dr. Philip, moving on in regions like South Asia, India and Pakistan are having complex water disputes. So, under the principle of cooperation, can this dispute be resolved between India and Pakistan under this principle? Do you see a possibility?
The possibility of cooperation is always there. The principles are there. Okay, so typically in South Asia, and it's the same if we extend it to China, in the whole region, none of those countries has ratified the 1997 UN Convention. But when it comes to having to discuss and debate some issue related to the sharing of a water course, whatever the words used, whatever the principles mentioned, whatever the terms mentioned, they will not be very far from these principles that we find in the convention. Again, because in practical terms, that's probably what makes sense in most cases. Now, after that, the principles, the legal regime is one thing that needs to be linked to a political debate. So it's always a question of the atmosphere has to be right for negotiations, which is what is called upon here to happen. And one of the weaknesses in that sense of the cooperative framework we have at international level for water is that it does not mandate much from states. And the whole point being to say that because it doesn't mandate much, most countries will join that framework and will understand these principles as being what they can work with. But the downside of it is that you need a cooperative framework in terms of the different countries in a given river basin willing to engage with each other on different topics, including on water. So that one cannot make up for the other. So it's not because you have an appropriate conceptual framing of principle that works, and that should also work, let's say, in this case of South Asian rivers, that it will necessarily work, because it's then up to the countries in question to take the debate forward. And given the way in which we have no world government, we have no international institution that can impose a certain type of settlements on countries, then that's something that goes back to the willingness of state to do things. So it's a bit of a vicious circle, and unless and until there is a climate of cooperation which is there generally, possibly nothing particular will happen with water. Which is probably why in the case of, let's say, if it's Pakistan and India, it's probably mostly the Indus river which is being talked about. Probably we would not be able to expect a new treaty at this point in terms of a new cooperative framework. But the fact is we have an existing cooperative framework. So there are also ways to make things happen in the context of existing treaties. And that's nothing particular, because we have the same thing with climate change at the global level. Today, it would probably be impossible to adopt something like the UN Framework Convention on Climate Change that was adopted in 1992. But because it's there and the problem is more and more significant and severe, the climate crisis is not well addressed, not sufficiently addressed at international level at this point, but it is being addressed to an extent. In a context where there is limited trust at this juncture in terms of multilateral systems, if we didn't have the convention, it's not clear that there would even be that much happening. So I suspect we can say the same in terms of a more specific river basin framework as well.
Dr. Philip, as we were talking about India and Pakistan, that there cannot be another treaty. So the Indus Water Treaty has been it made redundant due to the violations. And what do you think that what needs to change in this treaty to make it more compliant?
Okay, in this case, I guess the treaty is there. The framework is there. Nothing has changed in a way since 1960 when it was signed. Now, for any regime, any treaty regime to function in practice, there also has to be either a regime of compliance, which is there, so then some sort of international institution like we have, let's say in the case of the World Trade Organization, where there is quite a bit of pressure which is put on states to do what at that point, whether it's 1960 or 1995, they promised to do. If there is nothing, then clearly it depends again on the overall climate between the countries. Like now within this country, in this treaty, there is a little bit of pressure which can be applied because of the specific circumstances under which it was negotiated, with the role of the World Bank in bringing together the countries in the first place. That's something which obviously is at some level problematic because there is an external interference into the management of a regional river basin. That's not what the general framework is internationally. But again, now we have that framework in place. So at least there is a cooperative framework to work from. Now, when things are not working well, even in terms of implementing the treaty, the World Bank in this case still has a remote handle in terms of helping to foster the dispute settlement process. And that's the way in which we've reached a situation now where there is that case at the Permanent Court of Arbitration where the court said in July that the objection to the jurisdiction by one of the parties cannot be sustained and therefore they will take the case forward. So that's the first time that probably it's been so there's been so much distrust in a way between the two parties that they don't agree on the framing of a dispute or the way to resolve a dispute. But the good thing until now is that there is a framework, and that there is a framework which is institutionally already set up. So we have no idea what will happen in the future. That I have no clue. But what's for sure is that there is still hope because of that institutional framing we have. So for the time being, the two countries are not agreeing on the way in which the current dispute should be resolved. That's problematic because we would like, in the context of this treaty regime, that at least the framing for implementing and enforcing the treaty be agreed upon. But because it's there and because there is an international process which is ongoing, there is definitely hope at this point that the two countries can find a common ground in terms of the way in which to take this forward. So I would, at this point, I would not, I would hope that we would not want to say that the treaty has become redundant. Also, if the treaty became redundant, that would also be that there is no cooperation framework between the two countries. And if nothing else, that sharing of the rivers between the Western rivers and the Eastern rivers as a way to make sure that each of the two countries can manage to an extent their share of the water, all that would fall through. And then that would probably lead to much more severe consequences in terms of non-cooperation if it became a case of non-cooperation. So even though I know that the industry is often criticized for being weak, for being different things, for being inappropriate, but if we didn't have the industry at this point, I suspect that the things might be much worse in terms of the way in which the two countries engage with each other. And it's not a question of not having the treaty would solve the problem, because the two countries would still need to engage with each other in terms of the river. The river is, as is the case in so many other places, the river is just too important to be ignored. We will have the same things happening with the Nile and the conflict that we see arising between Egypt and Ethiopia in terms of that very large dam that Ethiopia has been building, which completely changes the framework of engagement between the upstream and the downstream countries. In that case, there is no treaty that binds Ethiopia with Egypt, and that's been one of the things that's been tried for the past 20 years, is to bring all countries in the river basin together under the principle of some sort of equitable use. That hasn't worked yet. But even though there is no treaty, and even though there have been various threats being put to Ethiopia in terms of don't fill the dam, don't do certain things, otherwise there'll be consequences, at the end of the day, the countries concerned are still behaving in terms of something looking like an equitable and reasonable use. And all countries are understanding that they can't go too far in terms of the extent to which they use or abuse of the river, whatever the words may be. So in that sense, there is always that understanding, it seems, somewhere, that you need to move towards a cooperation rather than the non-cooperation. And that fits with a broader paradigm, which is that, okay, there are conflicts over lots of different shared watercourses around the world, but the general framing that, okay, when we want to look at it positively, is to say that there is a lot more cooperation than dispute with regard to all these different shared watercourses. So that somewhere reflects at least an understanding that cooperation is needed, even if you don't like it at a certain point as a policymaker or as a political leader. And I suppose that's true even in those more conflictual situations like the Nile and the Indus. One of the reasons why things have not become worse over time, or have not been worse than they could have, possibly, is partly because everybody understands that there is a need for cooperation, even if you don't want to cooperate at some level, or even if you're not cooperating on other levels. Water is, again, just in the same way as water is seen as a commons, water is understood as being so important that you try not to bring it too far into any other type of conflict you may have. It could be a trade conflict, it could be a strategic conflict, whatever type of conflict it might be.
Dr. Philip, as you discussed that as we look at the other side of the coin, that at least we have a cooperation framework and we need World Bank. So, Dr. Philip, is there a case study in which states have shared resources successfully, water resources, and under the principle of cooperation?
But I guess, again, we are back to putting all these elements together. We don't have a definition of equitable use, so that making things work requires some level of common ground. Where there is more common ground, or maybe where countries have generally more positive relations with each other, it's easier to find that common ground. And where there has been cooperation for longer, generally between countries, it's probably easier to get positive outcomes. So it's probably not surprising that some of the cooperative framework we don't hear much about, or maybe less, in various shared watercourses in the European regions would be examples of successful cooperation. But maybe why we don't hear so much about is because it hasn't always been easy, and it's taken decades, if not centuries, for that level of cooperation to work more or less smoothly. And that doesn't mean that it's always smooth. Obviously, there's still disputes arising even in the European region. It's not at all to say that it's all become entirely smooth. But so there are various factors which probably explain why over time things may happen more easily. And that's because, again, the framework is relatively vague and it needs a long, sustained engagement between the different parties to work. Now, typically with the Nile, okay, we see that the engagement has not been for very long because we have that strange system where, or strange framing, where the downstream countries have tried to claim legal rights to the water in a way which is difficult to assert because they are downstream. And typically they had not engaged for a long time, until the last few decades, much with the upstream countries. And it's in that context that suddenly Ethiopia deciding to do something on their own, but not having really been in a cooperative framework with the downstream countries of Egypt and Sudan until then, suddenly that creates a new type of conflict. But in a sense, okay, fine, there is that declaration they signed in a decade ago or so in terms of ensuring that things are framed in a peaceful way in terms of the way in which the dam is being built and in the way in which the relations on concerning the Nile will develop between these three countries. And that, in a way, is a sign of a potentially positive framing taking shape. Okay, it's not yet the positive outcomes we may want to see, but in terms of a long-term process, it looks like this is a way in which there was nothing, there was possibly non-cooperation on both sides at the beginning because there had been no formal cooperation, so that makes sense. And relatively fast in this case, we seem to be moving to something relatively different. It's not yet completely different, but it is different. So I suspect that we can find examples like that, and they do exist. Again, probably going back to that idea that at some level, cooperation is more effective than non-cooperation, and also sometimes realizing that countries are codependent on each other for different things, so that water may be one element, but that there may be other elements in the broader equation of cooperation.
Thank you so much, Dr. Philippe, for your time today. And I really enjoyed the conversation. And I have learned a lot today.